Good morning, sir. Can you see and hear us?
Yes, thank you very much.
So yesterday I asked about an exchange of emails involving Mr. Williams in October 2019, on the 19th of October 2019. The reference was poll 3043169. No need to display at the moment. This was about the 14,000 kells that hadn't been disclosed before the Horizon Issues trial or during the Horizon Issues trial, and then the Post Office's proposed approach in relation to those 14,000 kells after they had been discovered. You asked Mr. Williams questions centring on the distinction essentially between disclosure and inspection. And Mr. Williams said, again I'm summarising, that there ought to exist correspondence which showed that the existence of the 14,000 kells had been revealed to the claimant solicitors Freeths, and that an index of such kells had been sent to Freeths. I'm very grateful to the Post Office and its lawyers who overnight have produced some additional correspondence to the inquiry. I'm not going to ask for the documents that I'm about to give the reference numbers to be displayed. They can be considered by you and the call participants in due course. There are 6 references. They are poll 00285691. That's a Womblebond Dickinson letter to Freeths of the 3rd of October 2019, poll 3043107, Freeths to Womblebond Dickinson of the 11th of October 2019, poll 00424141, Womblebond Dickinson to Freeths of the 15th of October 2019, poll 00424142, Womblebond Dickinson to Freeths of the 24th of October 2019, poll 00287839, Womblebond Dickinson to Freeths of the 28th of October 2019, and poll 3043187, Womblebond Dickinson to Freeths of the 1st of November 2019. Amongst that run of 6 letters, in due course, you'll find that it was the Womblebond Dickinson letter of the 3rd of October 2019 to Freeths, in which the existence of the 14,000 kells was first disclosed, and that it was Womblebond Dickinson's letter of the 28th of October 2019 to Freeths, in which an index of the 14,000 kells was attached.
Thank you very much, Mr. Bean.
Thank you, sir. So can we, Mr. Williams, pick up with where I left off last night, which was turning to the shredding advice. Can we look, please, to poll 406577? That's tab E6 if you want to follow it up.
Yes, I have it. Sorry, thank you.
Just waiting for it to come up on the screen. Poll 406577. Thank you. You should see this is a letter of the 2nd of August 2013. If we just pan out for the moment, you'll see that it was written by Andy Cash. I think you'll remember he was a member of Cartwright King.
Great.
And it's a letter to Hugh Flemington and Susan Crichton. And it says, I enclose for your urgent attention an advice prepared by my colleague Simon Clark. I'm sure you'll appreciate the advice is sent as part of our brief to advise on the impact of Horizon Issues and to protect the reputation of Post Office Limited. It's fully accepted you may wish to take a second opinion on the views expressed. Just on that line, was it part of Cartwright King's brief to protect the reputation of the Post Office?
I don't know.
Did you ever give any instructions to Cartwright King that, firstly, at all?
Typically not, but I think that we saw yesterday I gave an email which I think you could say was an instruction to make disclosure, and I probably did say things along those lines, but a formal instruction along that line, I don't believe I did.
Would you say it was part of
I
Cartwright King's brief to protect the reputation of the post office?
I don't know. I didn't work with them closely enough on matters to know whether that was or wasn't. I'm sorry.
In any event, the advice, if we turn it up, please, poll 406799. That's B79. This is the advice to which reference was made. It's an advice entitled Disclosure, the duty to record and retain material. If we go to page 2, please, and look at paragraph 5. He has earlier referred to the series of hub conference calls and says at some point, this is Mr. Clark speaking, following the conclusion of the third conference call, which he understands to have taken place on the morning of the 31st of July, it became unclear as to whether and to what extent material was either being retained or centrally disseminated. The following information has been relayed to me. 1, minutes of previous conference call had been typed and emailed to a number of persons. An instruction had been given that those emails and minutes should be and have been destroyed. The word shredded was conveyed to me. Were you given a copy of this advice?
So the specific advice note from that we're looking at, the document.
Yeah, the one we're looking at.
Yes, I was.
Yeah. So you were given a copy of this advice?
I saw it at the time. I'm sure I did. Yes.
Sorry?
I saw it at the time. Yes, I'm sure I saw a copy. I was given a copy.
What did you think when you read paragraph 5.1?
Well, it's an extremely serious allegation.
Presumably you're quite shocked to read it.
Yes.
Because you would have been reading it, Mr. Williams, in the context of having read the previous advice, the 15th of July advice, which was about an expert witness who it was said had breached their duties to the court, and that the post office had breached its duties to the court, and that taken together that may have an effect on the safety of criminal convictions. That would be the context in which you were reading this.
Not necessarily. I don't remember when I saw the 15th of July email, and I don't...
It's an advice, not an email.
I beg your pardon, advice. They certainly were arriving at the same time, but I'm not sure whether I connected the two of them or not.
But they were about the same thing, weren't they? One was the witness that the post office has been using is tainted. We need to set up a system to bring together information about possible bugs or problems in Horizon. That's been done. This is referring to that system, the hub, having been set up. And the reference being given is that the minutes of one of those meetings had been destroyed and the word shredding had been used. So the context, this isn't about a separate case, is it? This is about Horizon and its bugs and the expert witness.
One is about expert witness and prosecutions, and one
Yes.
is about a post office process going forward.
Do you think they're distinct things?
No, but they're not as connected as I mean, they are both relating to the response to Horizon issues, but one is talking about conduct of prosecutions, the first one, and the second one is talking about a post office internal management process.
Is that how you would have seen them, as divisible in that way? One's about just internal management processes, and the other one is about potentially the safety of criminal convictions?
I don't recall, but I don't recall. It's 11 years, I think, almost 11 years since this came up. I don't know what connections I was making between them. I'm sorry.
If we
To be clear, I do accept they're both dealing with Horizon. I'm not suggesting that, but I don't think they're quite as connected as
I'm making out.
Yeah.
Is that right? You don't think they're as connected?
I'm saying I don't know what I was.
Well, looking at it now, do you think there's a connection between the two? We get an advice saying that the safety of convictions needs to be looked at, in part because an expert witness hasn't disclosed some bugs about which he knew. We need to set up a system that records across the business so that the information isn't siloed. A weekly conference call to bring that information together, and then an instruction is being given that the record of that conference call should be destroyed or shredded.
So again, I think there's a lot of conflation going on.
Thank you.
And I'm struggling because I don't remember what my mindset was at the time, which is what I've been asked. But you said one is about the safety of convictions. Now, I can't recall, and I'd need to reread the advice note from 15 July in full, whether that followed from the advice on Jenkins on the 15th of July, whether that led to the review or that was, he was just saying you can't use them in prosecutions going forward. And this, which is about a post office management thing, which in and of itself, by the way, this in and of itself was serious enough. I'm not sure I did. I'm not sure I didn't make the connection at the time. But in and of itself, this is serious enough to warrant action.
And if we go on to page 6, please.
Yes, I have it.
And if we scroll down a little bit. And in paragraph 12, he says, the only proper way forward is for the conference calls to be properly minuted, those minutes to be centrally retained and made available to all those who properly require access thereto, were it to be determined that those telephone conferences were no longer to take place. The duty to record and retain nevertheless remains. Individual investigators with knowledge are bound by both the duty to record and retain and to inform the prosecutor, i.e. the Post Office Limited. Were you responsible in any way for carrying into effect that advice there?
In terms of carrying out the minuting? What particular part of the...
Any part, any or all parts, Mr. Williams.
I've certainly helped Susan Crichton, to whom I think the covering letter attaching the advice was sent, to respond to the advice and to confirm that the conference calls would be properly minuted and retained and made available. So to that extent, yes, I was involved in it. In terms of the physical actions of that, I don't recall being charged with holding the pen on the minutes.
Can we look, please, at poll 406797, which is E7.
Okay. Can I have the tab for that, please?
E7.
E7, thank you.
This is the reply by Ms. Crichton. If we look at the bottom of the page,
yes,
we can see it's signed off by her. Look at the top of the page, we'll see it's the 16th of August 2013, and it's her reply to the letter of the 2nd of August, so 14 days later. Thank you for your letter of the 2nd of August enclosing Simon Clarke's advice. Unfortunately, I had not seen your letter and was not aware of it until that's Martin Smith's email on the 14th of August. Do you know how that came about, that Ms. Crichton hadn't seen the advice until the 14th of August?
No.
Sorry?
No.
We've got some evidence from Simon Clark that he was subsequently told by John L. Singh that it had sat, the advice, in a drawer of yours between the 2nd of August and the 14th of August. Is that correct?
Not to my knowledge. I don't recall that.
Were you responsible for drafting this letter?
I think I was, yes.
And why were you responsible for drafting it?
I think Susan, the General Counsel, asked me to assist her.
Anyway, so she says, unfortunately, I hadn't seen your letter and wasn't aware of it until the 14th of August. The advice was prepared as a consequence of statements purportedly made in connection with the weekly conference calls. A key purpose of the conference calls is to ensure that Horizon users are promptly made aware of any issues with it. Next paragraph, I'm therefore deeply concerned at the suggestion in Simon's note that there may have been an attempt to destroy documentary material generated in connection with the Horizon calls, specifically any minutes of the calls. I note that Simon's advice does not suggest that material connected to the operation of Horizon itself may have been compromised. And then skipping a paragraph, I can confirm that we will continue to hold the conference calls for the foreseeable future and that minutes of those calls are and will continue to be taken. For administrative reasons, these minutes will be centrally stored with our solicitors Bond Dickinson, with access to those minutes being available to your firm and those you engage as expert witnesses. And I think if we look at poll 2019-3605, which is B67, we can see that in the terms it was sent out, you drafted this letter.
Uh, 67. I can only see part of it. Yes, I have it. Thank you.
Thank you. All right, that can come down. Who commissioned Mr. Clark's advice in relation to the destruction of minutes?
From recollection, I think he did it of his own volition. He considered himself duty-bound. I think it was the sort of feeling I've got to raise it immediately.
Okay, so it wasn't an instruction. It was because he'd become concerned about what he had been told that he sort of self-commissioned himself.
Yeah, I can't speak for Simon, but my impression was that was what had motivated it.
What steps did you personally take to ensure that the allegations recorded in Mr. Clark's advice were fully investigated?
I don't know what you mean by fully investigated, but I don't...
Hold on, stop there. You don't know what I mean by fully investigated.
Yeah.
What do you not understand about that sentence?
Well, investigations can be broad, wide, long, deep.
Okay. What steps did you take to ensure that it was investigated in any way whatsoever?
I don't know, but I felt able to draft a response, which I'd like to think was done with the benefit of some insight into what had happened and transpired. But
that doesn't say anything about what has happened. It says what's going to happen.
I don't recall. I'm sorry, I don't recall.
Is the answer none?
Well, I don't recall. No, the answer is I don't recall.
Do you think you ought to have taken some steps to ensure that the allegations made in Mr. Clark's advice were investigated in any way whatsoever?
I don't necessarily know that I would have at that time. I don't know that was something I was doing. I was asked to assist in a response, which I helped draft.
That's not an answer to the question. Do you think you should have ensured that there was some investigation?
I can't remember what happened at that time 11 years ago. So what I felt needed to be done or shouldn't be done, I can't recall now.
Well, looking back now, do you think there should have been some investigation into what Mr. Clark had said?
I'd like to think we responded to it prudently at the time in the manner we did. So I'm not sure what looking at it now adds.
Well, find out who it was who had allegedly given an instruction for minutes to be destroyed. Ask them about it. Find out why they had given the instruction. Find out whether minutes had been destroyed. Find out whether any other documents had been destroyed on the orders of that person or otherwise.
From recollection, I think we found out that minutes had not been destroyed.
Okay, so there was an
There
investigation.
must have been something for that, but I don't know when I recall knowing that piece, or if in fact that is correct. I genuinely cannot remember what happened in and around this time in terms of the steps taken that led to the production of this letter.
About 10 minutes ago, Mr. Williams, you told me that this allegation was in effect a serious or very serious, I forget whether you said very or not, but was a serious matter. I think it's fair for Mr. Beer to press you on whether you now think that serious matters of that kind should have been investigated.
Okay, thank you, sir, and my apologies if I've been unhelpful. It's not my intent.
So what's the answer to the question?
If I could have the question again, I will seek to answer it.
Should the serious or very serious matters raised in Mr. Clark's advice have been investigated by the Post Office?
Yes.
To your knowledge, were they?
I do not know.
You had responsibility, we've seen, for drafting the letter of response.
Yes.
Were you therefore involved in the response to the Simon Clark advice of the 2nd of August?
Yes.
Did your responsibility go wider than drafting a letter for Susan Crichton?
I don't recall that, no.
Who was responsible for investigating the matters raised in Mr. Clark's advice?
I don't know.
Was consideration given to reporting this matter to the police?
I don't believe so, no.
Did you find out that the allegation recorded in Mr. Clark's advice was attributed to Mr. John Scott, the then head of security? It was he that was said to have given the instruction.
I think I knew that John Scott was the head of security at that time.
That's a different question. That's an answer to a different question.
I beg your
That question would be, did you know that John Scott was the head of security? The question I asked is, did you know that the allegation recorded in Mr. Clark's advice was said to relate to an instruction given by Mr. Scott?
No, I did not know that. Not at that level of detail, no. Not the identity, no. I don't believe I did.
Would you have been concerned if you found out that it was said to be the head of security that had given an instruction to shred documents?
Yes.
Because he was the person in charge of the department responsible for investigating allegations of criminal offences against sub-postmasters and bringing proceedings against them.
Yes.
To your knowledge, was the information here disclosed to any convicted defendants?
I don't. At the time, I don't know is the answer, but it didn't form part of a disclosure review along the lines. To my knowledge, it didn't form part of a disclosure review along the lines that we had done for the bugs, the second site report.
To your knowledge, was this escalated, the information in Mr. Clark's advice, to the Post Office Board?
I don't know.
Should it have been?
I don't know what the higher governance was.
Can we turn to a different topic, please? Poll 406583. This is Mr. Altman KC's interim review. This is also dated, I think, the 2nd of August 2013, and it's his interim review of the Cartwright-King's current process. And in summary, I should say this is B75 for you, because I know you want to look at all these documents in those small files.
I have it, thank you.
Do you recall Mr. Altman's interim review?
No, not the interim review.
Were you responsible for commissioning it?
No, I don't believe I was.
Did you see it at the time?
I think I will have, yes.
Do you remember that he caveated the review that he conducted in a number of ways? If you look at paragraph 3, if we scroll down. And then look at paragraph 4. And then go over the page, please. And then look at paragraph 7. Paragraph 7 in particular, that the sole focus of possible complaint is the system and the single expert witness, Gareth Jenkins. And then paragraph 8, he sets out an assumption.
Mm-hmm.
And then over the page, paragraph, if we go down to 11. Over the page, thank you. He says that he wonders in paragraph 11 whether non-disclosure by Gareth Jenkins of aspects of the Horizon system is the only potential issue that arises in the case, or whether there may be other issues which need to fall within the remit of the review. And in 12, he questions whether the sole issue of non-disclosure is too restrictive an approach to take. When you read this, did you appreciate those caveats that he was including in his interim review?
I think some of them maybe, but not all of them. The general caveat that I remember is he'd be working on the information that we would be giving him.
Were you responsible, looking at paragraphs 11 and 12, for making decisions or contributing to decisions in the light of what's said there as to the nature of the review that Cartwright-King was to carry out?
I don't believe I was, no.
Whose responsibility was that?
I don't know.
You see what he's saying here?
Yes.
He's raising questions of whether the review that Cartwright-King is carrying out is narrow or too restricted or limited in nature.
Yes, I do.
Who was responsible for making decisions as to whether the review should be broadened or not?
Well, on this, I think in terms of the review, the sort of process was, as I understand now, having looked at some of the documents around it, is the scope was discussed, I think, with Womble Bond Dickinson, and then provided so I guess from Post Office, becoming from the General Counsel, from the Post Office legal team, working with Womble Bond Dickinson to Brian Altman. Brian then provided these initial comments, and then before the response was sort of finalised and agreed, which he would ultimately review. Is that helpful?
Maybe if we look at some documents, that will assist. Can we look at poll 00298123? And if we scroll down, please. Sorry, this is E123 for you to follow up. Are you at E123?
Oh, sorry, I am. I beg your pardon.
Can we look at the bottom of page 1, please? We'll see an email from Gavin Matthews, who was a partner at Bond Dickinson, yes?
Yes.
And he's writing to you, amongst others. And he said, I've now had the chance to review Brian Altman's interim review of Cartwright King's current process. So just to stop and understand what's happening, Cartwright King were conducting a review of some cases. Mr. Altman had conducted a review of their review, and now Bond Dickinson were conducting a review of Brian Altman's review of Cartwright King's review. Is that what's happening?
There's certainly a lot of reviewing going on, yes. But I think it's more that Cartwright King was proposing a course of action in response to prosecutions as a consequence of the second sight advice. Post Office was wanting a second opinion on whether that was the prudent thing, it was the right thing to do. And then, so Brian was instructed to look at that.
So he was reviewing their proposed review?
Yes, yeah, and at an early stage, because obviously if the review is inadequate and needed to be done, better to do it once than several times, so that if there were errors, mistakes, whatever it is, they could be picked up at an early stage and not all done in one go rather than in several. That's my understanding of the sort of review process. Cartwright King were doing it. We'd asked Brian to sort of take a look at that to see if it was basically to provide some assurance over the process.
So that was Mr. Altman's part of the process, or Brian as you know him.
I beg your pardon, sorry, it's Mr. Altman, but yes.
And then what was this? What were Bond Dickinson adding?
They were the conduit. I think they were the formal instructing solicitors to Mr. Altman in this, and so they were providing their input on the way through.
Let's just look at what they say. I've now had the chance to review Brian Altman's interim review, and then under 1, it's clearly good news that the current limited process Cartwright King have adopted is broadly fine. He, I think that's Mr. Altman, raises the issue of whether the current review is too narrow, and Mr. Matthews cross-references those 2 paragraphs, 11 and 12, that I've referred you to. He references the list of issues in the second site report and spot review 22 as examples of other issues which may need to fall within the ambit of Cartwright King's review. Whilst this should be put to Cartwright King, my own view is that it may be very difficult for Cartwright King to expand the review on issues on which second sight have failed to come to any conclusion. The possible conflict issue is well made, and Cartwright-King need to be alive to it. That's a part of the advice that I haven't taken you to, which is whether Cartwright-King lawyers reviewing cases in which Cartwright-King has been the prosecutor is appropriate, broadly summarised. And then geographical and temporal limits, only going back to the 1st of January 2010 and only looking at England and Wales, need to be reviewed and answered. And he says our advice, that's Bond Dickinson's advice, is Post Office Legal needs to disclose Brian Altman's interim review to Cartwright-King and discuss it with them. Was that done?
I believe so. I've got that from documents rather than.
Cartwright-King should be asked to respond in writing to the recommendations made. That's towards the end of Mr. Altman's advice. And Bond Dickinson should sit down with Brian Altman to walk him through the spot reviews and the second sight report so he can understand the impact of his review on the civil side. Who was the relevant decision maker here in responding to this advice about Mr. Altman's review of the review?
I would think it was the General Counsel.
So that would have been Miss Crichton at the time.
Yes. Yes. Sorry.
Do you recall what decisions she made in relation to the issues raised?
I don't. I'm sorry. No.
Were you party to discussions over what decisions should be made as to the, for example, the geographical scope of the review, the temporal scope of the review? Should it only go back to the 1st of January 2010?
I don't recall being party to those discussions.
I think you did attend a conference with Brian Altman, KC, on the 9th of September 2013, is that right?
Yes, I did.
You tell us about this. That can come down in paragraph 85 of your statement. Which is on page 43.
Thank you, I have it.
And we ask you to comment on 2 notes of a conference with Mr. Altman on the 9th of September 2013. You say although you recall attending his chambers on several occasions, you don't have any recollection of that conference specifically. You are likely to have attended to make sure the actions were being taken were joined up within the post office, and that you could take forward any that might apply to you. You've no reason to think that each of the sets of the conference notes fails to reflect what happened or omits matters that were material. You can't add anything. Yes? Can we just look at those notes of the conference? Poll 00139866. That's B81 for you.
Thank you. Thank you.
Now, I think this is the note of the conference, a typed-up note made by Martin Smith of Cartwright-King. So one of the 2 notes of the conference. And if you just scroll down, please. So you can refamiliarize yourself with the note. It's a long and detailed note, yes?
Yes.
I mean, it spreads in its typed version over 11 pages. In the course of the note, there's discussion in relation to Mr. Jenkins. Can you recall whether there was any information passed to Mr. Altman that the Post Office either knew or thought it likely that it hadn't instructed Mr. Jenkins properly as to the duties of an expert witness? There's no record of that in either this note or the other note.
Can you take me to the part of the note where it refers to Mr. Jenkins?
Well, it's spread across the note. People come back to it on a number of occasions.
So could I have the question again?
Well, yeah, so for example, if you look at page 4,
Yes.
and if we scroll down, please, it seems that, just scroll up a little bit, just under where the conference is discussing the bandwagon effect. Presumably the number of sub-postmasters trying to see how they can organise their defence. You get fashions, so have to be robust and not too free. So long as a DOP test can't go far wrong. And then Simon, I think that's Mr. Clark, goes back to, I think that's Gareth Jenkins. Either he was not aware of information or Fujitsu Ivory Tower not being taken seriously. And that's one of the occasions when there's a reference to Mr. Jenkins.
Thank you.
We saw in your handwritten note of yesterday that there was at least some recollection or recognition that it may be the case that the Post Office had not instructed Mr. Jenkins properly. Was that passed on to Mr. Altman?
I don't recall whether it was or wasn't, but I certainly have no positive recollection of that.
Can you recall whether there was any discussion about the Post Office's role as a prosecutor in obtaining and then disclosing the evidence of Mr. Jenkins in prosecutions? So rather than focusing on him as a man and what he had not done or had failed to do, whether the Post Office's role as a prosecutor was addressed?
I don't recall. I'm sorry. I've lost the question. I've lost the question. I'm sorry.
You're writing it down as you go along. If you want me to go slower, so you can write the question down.
I'm sorry. There are different
verbatim. I'm happy to do that.
I recall conferences with Mr. Altman about Post Office's role as a prosecutor, as in would we continue to do it going forward or not. But I'm just trying to follow the piece around. I don't quite understand the connection between Post Office as a prosecutor and Mr. Jenkins. It's what I'm trying to understand, sorry.
Was there any discussion, to your recollection, of the Post Office's role as a prosecutor, i.e. the duties that it owed when calling evidence that may be expert evidence?
Sorry, thank you for clarifying that. No, I don't recall that.
Can we look, please, at the alternative note, poll 406485? This is the Bond Dickinson note of the same conference. It's B80.
Thank you, I have it.
And if we look at page 3, please. And the first paragraph, in relation to the cut-off date, the 1st of January 2010 was close to the Horizon Online rollout. Prior to Horizon Online rollout, there was a cash audit done so that all post office branches balanced. Mr. Altman advised that there was no positive duty to seek out individuals before the 1st of April 2010, but if the post office was approached, it would need to make case-specific decisions on disclosure. Can you recall that being the material consideration on the temporal scope of Cartwright-King's review, i.e. there had been a balancing exercise undertaken, a cash audit undertaken?
That was, yes, that is my understanding.
And can you explain, please, why that was considered as important in not giving disclosure to convicted defendants where they had been convicted before the 1st of January 2010, or the conduct alleged against them had occurred before the 1st of January 2010?
No, I can't comment on that. That was a matter for the criminal lawyers.
Was there any discussion on how that worked, though, that the books were balanced, there was a cash audit done when Horizon Online went live, therefore we don't need to look backwards before then? Can you explain your understanding of the logic of that?
No, I can't. All I can understand is that and I think even then it's an imperfect understanding of the cash reconciliations that took place in the branches when Horizon Online was introduced.
So there was a cash reconciliation when they moved from Legacy Horizon to Horizon Online.
Yes,
so
that's my understanding.
There was a moment frozen in time when the books ought to have balanced or something ought to have been said about it.
Yes, correct. That's my understanding.
But why was that a reason to not look at the hundreds of people that had been convicted in the decade before the 1st of January 2010?
I don't know. I don't know.
Was there any discussion about that? Because the books should have balanced, or something should have been done about it in January 2010, we don't need to look at the hundreds of convictions that have been obtained before January 2010.
As I say, I don't recall the full details of the discussions then, but I think that point, I think Simon Clark may have dealt with it in one of his advice notes. There's a little bit more text around it, but I don't recall that. I don't recall recalling that at the time or being aware of it, and I don't recall a discussion around that in this consultation.
And just going back to page 2 of the note, please. Thank you. And at the last paragraph that we see on the present page, Mr. Altman is recorded as advising that the Post Office and Cartwright-King should ensure that the disclosure procedure is beyond reproach. And then it was widely agreed that there was likely to be a bandwagon approach in relation to defendants challenging their previous convictions. Can you remember who made the bandwagon comment?
No, I can't. I'm sorry.
It's recorded that it was widely agreed. Presumably that's widely agreed amongst the people that were present.
Yeah. Yes, I assume so, yes.
And you were obviously one of those. Why did you agree that there was likely to be a bandwagon approach?
Sitting here today, and quite possibly at the time, if something gains currency, people will gather around behind it. That seemed logical to me.
So improperly pass or jump upon something that was passing in front of them?
I don't know about the improperly hopping on, but certainly getting behind it, yes.
So maybe legitimately
Yes.
appealing their conviction?
Yes.
Or seeking to?
Yes.
Is that the sense in which the bandwagon was used? People might legitimately here seek to appeal against their convictions. Is that the bandwagon that was being spoken about?
I don't recall there being a distinction between legitimate and illegitimate bandwagoning, if that's an expression.
Thank you, Mr. Williams. That can come down. Can we turn to a separate topic, please, remote access? And turn up paragraph 105 of your witness statement, please. Which is on page 53.
Thank you, I have it.
Under the heading, My Involvement with the Instruction of Deloitte. If you just read that to yourself.
Yes.
In the fourth line, you say, I understand that the aim was for Deloitte to provide an objective report into the reliability of Horizon. Yes?
Yes.
And that was your aim, was it, to get Deloitte to produce an objective report?
The aim was certainly for Deloitte to come in objectively, yes, and then produce a report. So, yes, that's the answer, sorry.
Can we look, please, at poll 0012 5744? That's E72. We can see that this is an initial step that you took on the 2nd of April 2014 to instruct Deloitte, yes?
Yes.
It's addressed to Gareth James of Deloitte. And you say, as discussed earlier today, Post Office is responding to allegations that the Horizon IT system is defective or the processes associated with it are inadequate. In order to respond to these allegations, which have been and will in all likelihood continue to be advanced in the courts, Post Office wants to demonstrate that the Horizon system is robust, fit for purpose, and or operates within an appropriate control framework. That doesn't particularly suggest that the Post Office was looking for objective findings, does it?
Well, I think it demonstrates what the Post Office wants to do, but we're instructing Deloitte to come to their own opinion.
Why were you setting out the outcome that the Post Office wanted if you wanted an objective report?
I think it's just the language I used at the time.
Well, I know that, it's on the page, but I'm asking you why.
I don't know. I was trying to instruct Deloitte to act independently. I might have said would like or would hope or needs, or I could have used a number of words. I think Post Office did want to demonstrate that it was robust because we were using it.
So why did you set out the conclusion you wanted them to reach?
I haven't asked them to reach that conclusion.
Why did you set out the conclusion that the Post Office wanted?
I'm sorry?
Why did you set out the conclusion that the Post Office wanted?
I'm sorry, I don't think, I'm saying that's what we want to demonstrate, but
yeah. Why did you do that?
I don't want to be flippant, but, so I won't be, sorry, that's not right. There are many things people want, but they don't always get them.
Is that your best answer?
Yes.
I'll move on then.
I certainly wasn't trying to steer a direction in a first email.
Can I look at some statements? Sorry, before we look at some statements on what the Post Office was told about remote access and information given to the Post Office about remote access. Having been directly involved in the instruction of Deloitte, you would naturally be very interested, wouldn't you, when they produced their report as to the conclusions which they reached?
Yes.
And you would have read it assiduously, wouldn't you?
I read it as well as I could when I received it. Yes, the content was of interest, yes.
Yes, it's not a piece of work commissioned by someone else in the business that happens to pass across your desk with you being a copyee amongst many others to emails.
No, it's not. No.
You were the point man again for the instruction of Deloitte.
Yes.
And therefore, when they produce the report and it comes back directly to you, you'd be interested in what they wrote, wouldn't you?
Yes.
Thank you. That can come down, thank you. Can we look, please, at some information that was given to the Post Office about remote access? And first off, look at paragraph 101 of your witness statement, please.
I'm sorry, which paragraph?
101.
Thank you.
Which is on page 50. And you're here dealing with the issue of remote access as it arose in the context of the mediation scheme, yes?
Yes.
The inquiry's asked me to comment on an email sent to Mr. Parsons in April 2014 concerning an internal post office email from 2008, and you give the cross-reference. That's called the Win-Lusher email from 2008. As far as I can tell, I first saw the 2008 internal post office email, that's the Win-Lusher email, when I was sent it on the 14th of April 2014 in the context of a scheme claim. The email, that's the Win-Lusher email, raised the issue of remote access, albeit in a different manner from the way remote access was raised by Michael Rodric. I discussed this with Andy Parsons, who drew out for me the questions it raised for Post Office, but which Fujitsu need to answer. These questions were then sent to Fujitsu, whose responses were provided to me on the 17th of April, and I believe it was related to Second Sight. I believe the question of how and to what extent Fujitsu had the ability to alter Post Office branch data remotely continued to be explored with Fujitsu. So dealing with this issue of the 17th of April email, can we look at that, please? Poll 00304478. That's B100.
B100, thank you.
And if we turn up, please, pages 4 and 5.
I have them, thank you.
So essentially what happens is that Second Sight, in the context of their mediation scheme, had raised some questions about remote access, yes? And you were putting these to Fujitsu.
Yes.
And this is Fujitsu providing the answers, yes?
Yes.
And Mr. Davidson of Fujitsu, James Davidson, says, please see Fujitsu's response below. Summary, there's no ability to delete or change records a branch creates, either in old or New Horizon. Transactions in both systems are created in a secure and auditable way to assure integrity and have either a checksum old Horizon or a digital signature. Horizon Online are time-stamped, have a unique sequential number, and are securely stored via the core audit process in the audit vault. Whilst the facility exists to inject additional transactions in the event of a system error, these transactions would have a signature that is unique. Postmaster IDs are not used, and the audit log would house a record of these. As above, this does not delete or amend original transactions, but creates new and additional transactions. This facility is built into the system to enable corrections to be made if a system error or bug is identified. And the master database needs updating as a result. This is not a unique feature of Horizon. Approvals to inject new transactions are governed by the change process. Two-factor authentications and a 4 eyes process. A unique identifier is created and can be audited for this type of transaction within Horizon Online. Horizon would require more extensive work to investigate, as explained below. And then answers to the direct questions that you had posed arising from second sites questions. One, can Post Office change branch transaction data without a sub-postmaster being aware of the change? No. But then two, can Fujitsu change branch transaction data without a sub-postmaster being aware of the change? Answer, once created, branch transaction data cannot be changed. Only additional data can be inserted. If this is required, the additional transactions would be visible on the trading statements, but would not require acknowledgement or approval by a sub-postmaster. The approval is given by Post Office via the change process. In response to a previous query, Fujitsu checked last year when this was done on Horizon Online, and we found only one occurrence in March 2010, which was in the early pilot for Horizon Online and was covered by an appropriate change request from from Post Office and an auditable log. For old Horizon, a detailed examination of archived data would have to be undertaken to look into this across the lifetime of use. This would be a significant and complex exercise to undertake and discussed previously with Post Office, but discounted as too costly and impractical.
Yes.
Overall, what did you take from either the summary or the detailed answers that were given as to the ability for data to be changed without the knowledge of a sub-postmaster?
It couldn't be done.
It couldn't be done.
It couldn't be done.
Even notwithstanding the answer given to question 2.
And what I understood question 2 to say is you couldn't change the data, but the overall position, say, of a branch's account could be changed by the injection of a new and identifiable entry.
Did you regard that as an important point, that although data couldn't be changed, the overall trading position could be amended by the injection of new data?
Yes.
Did you realise the distinction between those two things at the time?
I think so, yes. But I have to say I'm saying that today, so.
Now, it seems that that can come down, thank you. On receiving these answers from Fujitsu, Mr. Parsons produced a draft note for second sight, which he sent to you for approval or comment. Can we look at that, please? That's, I think, at the beginning of B100. In fact, it's sent to Angela van den Boogaard and copied to you. So that's the same document we were looking at, poll 0030 447, page 1. I'll just wait for it to come on the screen. Maybe if we look at 2 first, page 2 first. We can see his direct email to you copied to Ms. van den Boogaard. Have you had a chance to look at the attached note? I'm not going to look at that attachment now. Second sight are pushing for an answer to this. so they can build it into the fact file. So we need an answer as soon as possible. The question posed by Second Sight is, as requested at the working group meeting, Post Office are asked to produce a formal certification that it's not possible for anyone to access Horizon or Horizon Online and amend transaction data without the knowledge of the sub-postmaster or their staff. What did you understand by formal certification?
I'm not sure I did. I wasn't engaged directly with Second Sight on this, so I'm not sure of the style they were after.
A response to the question is proposed to you by Mr. Parsons. Did you think that this equated to the response that the Post Office ought to give?
I might just reread it.
Yeah.
I mean, it's a summary. I don't know whether it was going to be sufficient for Second Sight's purposes or not, because I wasn't quite sure what they were after, but it seems a summary, yes.
It takes the point that it's not clear what's meant by certification, but we've gone off to Fujitsu and the Post Office's IT team. To your mind, did the summary which then follows in the second line onwards of the proposed response properly summarise the information that Mr. Davidson had given you?
As I say, it's a summary, and I think it's consistent. But whenever you summarise something, there's always the risk you leave a baby, you put a baby out with the bathwater. But I thought it was a fair summary, yes.
What about the fact that, in answer to question 2, you'll recall that Mr. Davidson had said that additional data can be inserted, but that would not require the acknowledgement or approval of a sub-postmaster, approvals given by the Post Office itself? It doesn't reflect that, does it?
Well, I'm sort of looking at, although it is not specifically, as I say, it's a summary, but it's possible to input transactions, and they will have visibility of the extra transactions as they're shown separately in the branch's accounts. So I think that the visibility point was seeking to address that.
Okay. Can we look then at the Deloitte report, which was the 23rd of May 2014, poll 0002 8062, that's B119.
I have it, thank you.
So this is about a fortnight after that summary for Second Sight was being compiled. Yes?
Yes.
No, a bit longer than that. It was about a month after.
I beg your pardon.
Yeah, we were looking at the 22nd of April email
thanks.
exchanges, and this is the 23rd of May.
That's a month. Thank you for clearing that up.
This was delivered directly to you, yes?
I don't know if it was delivered directly to me, but I received it. As in, I don't know who else, I can't remember who else got this or when.
Can we look at page 31, please?
I have it, yes.
If we just scroll down a little bit, under hardware controls over the audit store, the Centauri MC devices used to host audit stored data have not been configured in the most secure EC Plus configuration. As a result, system administrators on these boxes may be able to process changes to the data stored within the audit store if other alternative software controls around digital seals and key management are not adequately segregated from the Centauri box administration staff. Privileged access to the cryptographic solution around digital signatures and publicly available formulas on MD5 hashed digital seals would potentially allow privileged users at Fujitsu to delete a legitimate sealed file and replace with a fake file in an undetectable manner. And then further down the page at the bottom, last bullet point, controls that would detect when a person with authorized privilege access use such assets to send a fake basket into the digital signing process could not be evidenced to exist. When you read the report, did you spot those 2 points?
I don't know whether they jumped out at the time or not. I don't.
You tell us in your witness statement, no need to turn it up, that it's regrettable but not deliberate that when a statement was made to the BBC,
Yes.
That it's not possible for the Post Office or Fujitsu remotely to edit transactions as they were recorded by branches, which was incorrect, that you essentially had missed these paragraphs inadvertently missed these paragraphs in the Deloitte report.
Yes.
Is that right?
Yes, it is.
So that's making incorrect statements to the BBC. But what about Second Sight? If we go back to Second Sight, poll 3030-0160, that's E24. This is the Second Sight report of the 21st of August. And if we go forwards to paragraph 11.2, so I'll let you catch up, E24.
Thanks, I have the document.
Yes, and if we go forwards, please, to page 14 at the bottom. Thank you, got it.
I have it, thank you.
Post Office has confirmed that it's not and has never been possible for anyone to access branch data and amend live transactional cash or stock data without the knowledge of sub-postmasters or their staff. Did you read this Second Sight report?
Yes, but I don't recall doing it particularly in detail. I'm sure I did, and I'm sure I reviewed it. I don't wish to convey.
Did what you read there, which does accurately summarise what the Post Office had said to Second Sight, clash with either what you had been told in the email exchange of April 2014 or the knowledge that you had, constructively at least, from the Deloitte report?
So looking at the consistency point is probably noted as in it is consistent with the summary that was provided, the interim summary, I think Andy described it as in the email. I think when I reread this to try and understand why, to try and piece together for the purposes of this inquiry, how I missed it. when I look at the, can we go back to the Deloitte report section you took me to earlier?
Yes, of course, that's poll 00028062.
I think you said
Which part do you want to go
I
to?
think it's page 31 from memory.
Yeah. Page 31.
Yeah, thank you. So when you look at section, and I'd like to stress, this is something I've reconstructed for the purposes of here, so I don't wish to say this is what I was thinking at the time because I don't recall. But what was described over the controls over the audit store was that it looked like it would require a deliberate circumvention of controls for that risk, those sorts of transactions to be entered. It says sort of if other controls and key management are not adequately segregated, so there's that had to be a breakdown. Administrative staff with access could basically remove, change, and reinsert an entry, but it would require faking a key, so some form of deliberate action in order to do it. So we're starting to get into theoretical extensions. And I think I also saw an email from one of the Deloitte team members who explained this to me in a little bit more detail. And he said, we're still looking into it, and there may be other controls around it, including...
Well, after this report, they sent an email.
I can't remember whether it was before or after. I'm sorry.
And what it was explaining what this meant.
What that finding was, yes. And it struck me as being unlikely. If I may, and I don't mean this in a legal sense because I'm not sure whether it is or not, but it would be deliberate wrongful action. It would be a fraudulent action required to do it.
And therefore would be inherently unlikely.
That's what I'm thinking. But as I say, I am reconstructing. I'm sorry.
And just to explore the logic that you're reconstructing, why would it be inherently unlikely that a person would commit fraud?
Normally, you do it for personal advantage, and you can see how that would flow from this.
So, i.e., they would personally have no gain from it.
Correct. What I think I was a bit more interested about is section G, which dealt with the balancing transactions and the insertion of the additional things that we had been or seeking to flag, and I think we also sought to flag with the BBC as part of this continuous line. But we certainly missed this. Well, I beg your pardon, I certainly missed this.
Did everyone miss it, to your knowledge?
Well, I think others missed it as well, because others had access to this report.
And nobody picked it up and nobody corrected the past statements that had been made, either to the BBC or to Second Sight?
I think two bits, and it's yes to both.
Can we go forwards then, please, in the interest of time, to poll 30913994. That's E48. This is an email of the 10th of October 2014 from Melanie Caulfield to a group of people, including you. Can you see that? In fact, we probably better look at page 2 first and then come to page 1. Second site, so let's just scroll up to see what, who was saying what, a little bit further, thank you. Jessica Barker, to a group of people including you, to a draft CRR for case number MO53. Some background to this, you'll remember that Second Sight originally uploaded a draft some weeks ago. It transpired there were some exhibits they hadn't shared with Post Office, with new exhibits. Post Office re-investigated and produced an updated report. They're both attached. Bond Dickinson will produce the draft response for settlement and settlement analysis by a date. Please reply all with your comments. Yep. And then if we go to page 1, at the foot of the page, Belinda Crowe says, is this the first which references remote access? Yes, so the first case in the mediation scheme which refers to remote access. And then she says, I think we need to pick this up very robustly in our response, as this could become public. And Second Sight seemed to be asking for proof that something didn't happen. Could we dust off our lines on this? And then up the page, please. Melanie Caulfield says, our current line, if we're asked about remote access potentially being used to change branch data transactions, is simply, this is not and never has been possible. This line holds, but if we're pressed regarding Second Sight's points about admitting there is remote access, we can say there's no remote access for individual branch transactions. We might get pushed further on it and be asked by the media to confirm whether or not there's any remote access. We'll need to make the distinction, re-access, as straightforward as we can. So suggest there's no remote access for individual branch transactions. Fujitsu has support access to the back end of the system used for software updates and maintenance. This is, of course, strictly controlled with security processes in place, but could not, in any event, be used for individual branch transactions. There is no facility at all within the system for this. On the basis of what you've been told by the 17th of April email and what was in the Deloitte report, those lines to take were not accurate, were they?
No, they're not. We do know there is. Sorry, no, they're not.
And I think, to your knowledge, did anyone point out that those lines to take were not accurate?
I know at various times I saw it, but I don't know in the timeline overall. At various times I sought to draw to the attention the balancing transaction possibility, but not the audit store one we've talked about. But I don't know in connection with this email and the time of it. I don't know whether that was done or not at that.
Thank you, Mr. Williams. Sir, that might be an appropriate moment to take the morning break. Can we say till 25 past, please?
Yes, certainly.
Thank you very much. Good morning, sir. Can you see and hear us?
Yes, I can. Thank you.
Thank you. Mr. Williams, before the break, you mentioned an email that you received from Deloitte, and you weren't sure whether it was before or after their report of the 22nd of May, 2014. Can we look at it, please, to try and help you? Poll 302-9728, and that's B112 for you.
I'm sorry, B.
112.
I beg your pardon.
And can we go to page 3, please? And look at the email at the bottom of the page.
Yes.
We can see this is the 20th of May. If we just scroll up a little bit. And it's your exchange with Mark Westbrook of Deloitte, yes? So we can see it's before the report.
Oh, okay, there you go. Thank you.
And you say, in the course of preparing your board update, you identified an example where a horizon control was not implemented as understood. I understand you've since done some further work to better understand the risk this may present to the integrity of the data held in the audit store. Can you please send me a summary of this technical issue and the controls that are in place? I don't need a narrative of how the issue came to be identified or investigated, just a statement of the current position. And just to make clear, this debate you're having is about a Horizon Online only, not looking backwards to the position as it was in Legacy Horizon.
I can't say now, but I'm not sure I'd have been making that distinction, although actually, as I say that, Deloitte were only looking at Horizon Online. So yes, that would be correct.
Thank you. And then if we look at page 2, and scroll down, please. This is his reply. He says, so the key difference for our purposes is that accounts with correct access rights would be able to delete but not modify existing audit store records. This risk should be largely mitigated by the unique sequence numbers. There remains a small risk that someone with the requisite access rights to the digital keys used in the sealing process and admin access could theoretically delete an audit store record, recreate the transactional data that was originally within the audit store file to suit whatever purpose they might have, seal it using the correct key to generate a valid seal value, reinsert it into the database. You would need to alter the database of seal values as well to make this change undetectable. There is an additional complexity that the transactions themselves are also digitally sealed by a digital signature. Question therefore becomes, does anyone have the requisite access to the Centira boxes and rights to key management to be able to exploit this? This is currently with one of the Fujitsu staff. You'd obviously, before receipt of the report, centred on or highlighted for yourself this important issue of remote access.
Yes.
And this exchange all takes place on the 20th of May. Yes?
Yes.
So when you get the report on the 22nd of May, presumably having highlighted for yourself the importance of what Deloitte were going to say about remote access, you would especially pay attention to the bit of the report which concerned remote access.
I would like to think I did that. I think that's fair, probably yes.
And so how come what we saw on page 31 was missed by you then?
As I thought to explain, I think, and this tends to support it, is that it was a theoretical possibility that had controls around it to mitigate the risk, which was small and was being investigated further. And so I think off the back of that, I clearly went from my mind because I don't recall it popping up for when we were being asked later about lines on remote access, what to say to interested parts of the public about remote access.
That's a slightly different answer to I inadvertently missed on page 31 of the Deloitte report the reference to remote access. That I did clock it, speaking colloquially, but I thought that it was only a theoretical possibility and therefore could be dismissed from any answers that we were giving.
I'm sorry if I've been imprecise with that. That's I apologise for that.
So it's the latter category that you realised that this form of remote access was possible, but because it was theoretical and you couldn't understand the motive of anyone that wanted to do this, you put from your mind when formulating responses the need to include such a reference.
No. I'm stressing this is where I've got to, having tried to reconstruct the events for the purposes of this inquiry. So I'm not trying to say that was happening at the time. I genuinely don't recall what happened at the time.
I understand.
But I know I missed it, so I wanted to find out why.
Can we move forward? That can come down now to the following year in March 2015 and look at poll 00312743. That's E126 for you.
Thank you.
And can we look at the bottom of the email, please? Thank you. Have you got that?
I do, sorry, thank you.
It's an email of the 3rd of March from Andrew Parsons to, amongst others, you. And it concerns the case of Wiley, another one of the mediation cases. And Mr. Parsons says, we've been through the prosecution file for Wiley. There will be further documents to disclose, including the attached witness statement of Gareth Jenkins. At the top of page 3, Mr. Jenkins states, I also note a comment about it being possible to remotely access the system. It is true that such access is possible. However, in an analysis of data audited by the system, it is possible to identify any data that has not been input directly by staff in the branch. Any such change to data is very rare, and it would be authorised by Post Office Limited. As I've not had the opportunity to examine data related to this branch, I cannot categorically say this has not happened in this case, but would suggest it is highly unlikely. Then Mr. Parsons says, I'm pretty certain that Mr. Jenkins is referring to the balancing transaction process that allows Fujitsu to input new transactions rather than edit old transactions. Nevertheless, this will be a red rag to Second Sight. Can we discuss? I don't think we need to bottom this out before the Second Sight meetings. We'll just say we're working on reviewing the legal files. And then scroll up, please. And stop there. You say this is consistent with our responses, statements about remote access, isn't it? I.e., you can add data, inject a balancing transaction, and if done, quote, it is possible to identify any data that's not been input directly by staff in the branch, question mark. And then scroll up. And Mr. Parsons says not quite. We say that transactions entered by sub-postmasters cannot be edited, but we don't go on to say that Fujitsu can input new transactions in exceptional circumstances. This information would therefore be entirely new news to Second Sight. Can you explain what the Post Office did at this stage to explain to Second Sight that Fujitsu could inject new transactions into branch accounts in exceptional circumstances?
This is one of the documents, I think, that was reasonably late, so I wasn't able to...
Sorry, late?
Sorry, not late. I didn't mean to say that. I received it lately. I got it last Friday. And I in the time, I haven't contextualised this to know what we went on to do with this or what I was doing at that time. So I don't think I can answer your question. I'm sorry.
Do you think something should have been done to reveal to Second Sight that, in fact, Fujitsu could inject new transactions into branch accounts in exceptional circumstances?
Well, I think that was happening through the balancing transaction issue, which was being, but I don't know where that sits in the timeline on this. I'm sorry, that's what I was trying to say around contextualising. I don't know what we did around that. I recall that we were going to lengths to acknowledge the balancing transaction issue.
Do you think this is talking about balancing transactions then?
To me, whenever we talked about injecting, that was the balancing transaction. That was putting something new in.
Can we move on then to poll 302-9843? This is another Simon Clark advice. It's dated the 27th of March 2015.
Thank you.
And essentially it concerns the issue of whether the Deloitte report of May the previous year needs to be disclosed. If you scroll down, he says in this note, references to Deloitte, the Deloitte report are references to draft 16 of the report. In fact, the version there is the 23rd of May.
Could I have the reference for this one, please?
Sorry?
Could I have the reference for this one, please?
Yes, I haven't got a tab number. I'm sure Mr. Stevens will assist.
Thank you.
Poll 302-9843. Triple 02-9843. B174.
Thank you, I'm grateful. Thank you.
And a passage which is on the screen, paragraph 2, page 31, paragraph G of the Deloitte report identifies a method of posting balancing transactions, that is, the posting of additional transactions centrally without the requirement for these transactions to be accepted by the sub-postmaster. The paragraph goes on to indicate that whilst an audit trail is asserted to be in place over these functions, evidence of testing of these features is not available. Later extracts for this paragraph are also of concern. For balancing transactions, we did not identify any controls routinely to monitor all centrally initiated transactions to verify that they are all initiated and action through known and governed processes or controls over the page to reconcile and check data sources which underpin current period transactional reporting for sub-postmasters to the audit store record of such activity, and controls that would detect when a person with authorised privilege access use such access to send a fake basket into the digital signing process could not be evidence to exist. So he's picking up essentially the points that were on page 31 of the Deloitte report. Agreed?
Agreed.
And he says this material is potentially disclosable in cases where a convicted defendant has raised as part of his defence the suggestion that, scroll down please, Post Office or some other third party had manipulated, interfered or otherwise compromised Horizon. Horizon had created or was the victim of a system-generated but inexplicable loss, entry or transaction, or the defendant simply had no idea how the relevant loss arose. When you read this advice, because I think it was sent to you, did you return to the Deloitte report to consider the extracts identified by Mr. Clark in context?
I don't recall doing that, no. I may have done, but I don't recall doing that.
You, I think, tell us in your witness statement that it wasn't until the SWIFT review that you became aware of the conclusion of the Deloitte report on page 31 as to remote access. I'm summarising your witness statement.
Yeah, I've said what I've said in my statement on that, I think.
What was done as a result of this advice by you?
So by me, I think I tried to describe part of my role when ISA didn't have the capacity to deal with matters. I would try and ensure that the legal support to address it for the business was picked up by those we're instructing or available to deal with it. So I don't recall taking this forward, but I think you can see from this, as I'd sought to join up Womblebon Dickinson, who are supporting Post Office on issues arising out of the scheme, the mediation scheme, with Cartwright King to make sure that those developments were properly considered from a criminal law perspective. And so long as I could see that direction of travel, I left them to it, I think.
To your recollection, that can come down from the screen, thank you. Was it really only until Jonathan Swift in 2016 identified the importance of the Deloitte conclusion that the Post Office, so far as you were aware, woke up to the importance of the Deloitte report?
The report on the audit store access,
Yeah.
that's my evidence. That's what I recall now. So yes, it is. And I regret it, I promise.
And so, to your knowledge, quite a few people missed this.
I think if we see Simon had the same report and is focused on the balancing transaction section when the audit store piece is equally above it. but I can't speak for Simon on that. I'm sorry. That's just something I noticed when I was looking at it recently.
Can we turn to what happened when maybe the penny started to drop at E19 for you, for us, poll 3002 8057?
Thank you.
This is a note of a internal meeting attended by 3 members of Deloitte, including Mr. Westbrook, with whom you'd exchanged emails, and 4 members of the Post Office. It doesn't include you. Yes?
I can see the document.
And it concerns Project Sparrow and the chairman's report recommendations. After introduction, if we can scroll down to paragraph 2, under the legally privileged character of proposed work and the applicability of non-disclosure agreements, Mr. Bork articulated the importance of being able to assert legal privilege over any pieces of work that were commissioned in response to the recommendations included in the chairman's report. Did you have any part of drawing up or involvement in the chairman's report?
I did have involvement in the chairman's report, yes.
And can you explain what the chairman's report was then?
Yeah, sorry. And I might need some help with the dates because they do blur. I think it was sometime in, is it mid-2015? August 2015, maybe? Around that time, I think Post Office had a new incoming chair called Tim Parker, who I understood had been asked by certainly a minister with responsibility, some form of responsibility or oversight of connection to Post Office, to look into the Postmaster Horizon complaints to see what had been done to date and whether anything more ought to be done. And off the back of that, the chairman decided to undertake a review of those actions to see what else could be done. In shorthand, it was a sort of gap analysis, I think. But that may not be a fair description of it. That's one way I looked at it.
And here Mr. Bork was setting out the importance of being able to assert legal privilege over work that was commissioned in response to recommendations included in that report, yes? Can you recall having been tasked to produce a document following that note there? If we look at the second...
Directly in response to...
If we look at the second page...
I don't recall seeing this note before. I may have been sent it, but I don't have any recollection of this. And
if we look at the second page...
Thank you. Oh, here we go. Thank you.
Mr. Witten, I think that is, Andrew, asked, referencing his email to you, that a frequently asked questions type document which addresses how to maintain legal privilege be produced, and whether the existing non-disclosure agreement with Deloitte would suffice for this piece of work, or whether the letter of engagement for the June 2014 work could be reused or tweaked. It will be necessary for new non-disclosure agreements and engagement letters to be required. And the Post Office said it would confirm with its General Counsel. Do you recall being tasked after this meeting, the 4th of February 2016, with the production of an FAQ document addressing how to maintain legal privilege?
Sorry, just two things. We've referenced an email to me that I don't recall seeing, but the answer to your question is I don't recall being tasked with that, no.
Can you recall discussion at the time of how important it was that either through a non-disclosure agreement and or legal privilege, that work conducted by Deloitte should enjoy protection from disclosure?
I don't recall that specifically, but I do think it's right to say that Post Office was keen to be able to assert privilege, if appropriate, over Deloitte's work. I think
Why was that?
because I think there was, by sort of February 2016, was two things. One, well, actually, I don't actually know what the work is here, so I don't know what the meeting is, so I don't know there. But there's, at this time, we're very, very close to the group litigation starting. We may have had contact from Freeths by this time, I think over a year before there'd been a press release around the time that the mediation scheme was breaking up, that I think Edward and Co. had been consulted about a claim, and so there's this feeling that litigation was imminent.
And so it was that legal proceedings were in contemplation, or you thought in the minds of others they were in contemplation?
For the purpose of, I'm not necessarily sure, because we need to look at, but there was a feeling that we were going to get sued. In fact, it may have been more than that. There may have been strong indications by this time, but again, I haven't been able to contextualise this particular bit, so I'm worried I'm overreaching with my memory.
Okay, thank you. That can come down and you can put it back in your file. At this time, was any action taken to correct the statements that had been made either to the BBC or to Second Sight?
No. Sorry. I don't know about probably not. I don't recall any steps being taken. I definitely don't think any went to the BBC. I don't know what the engagement with Second Sight was at that time, but I suspect it was minimal.
Do you know why such, if it is the case that no steps were taken to correct statements that had been made, why that was?
I don't know why we didn't do something, I'm sorry.
And then the last topic from me, please. Were you a party to discussions over the use of Gareth Jenkins as a witness in the group litigation?
I believe I was, yes.
Can we turn up paragraph 240, please, of your witness statement? Which is page 122. So 240 is at the foot of the page. And you say that a conference was held in September 2018 to discuss whether to rely on Gareth Jenkins as a witness at the Horizon issue trial. I attended that conference along with counsel for the Horizon issues trial, Anthony DeGar Robinson, Queen's Counsel, Simon Henderson of counsel, Simon Clark and Martin Smith of Cartwright King, and Andy Parsons of Womblebond Dickinson. As can be seen from an email, there was a concern about using Gareth Jenkins as a witness in the Horizon issues trial, given his previous role as a prosecution witness, and that Simon Clark's advice to the Post Office was that his credibility as an expert witness had been, quote, fatally undermined. I'm just stopping there. Now, so far as I'm aware, we haven't got a note of that conference. At least I haven't been able to find one, despite the number of lawyers that were there. But can we look, please, at your view before you attended the conference by looking at poll 304-2015, which is B280.
Yes, thank you.
Have you got it?
Yes.
It's an email from you to Mr. Clark, Mr. Smith and Mr. Parsons. ahead of the conference, and you say in advance of the con with council on Monday, please see email below and attachments. And then if we scroll down, so you can just get some context, and then keep reading. And then scroll down, please. And then at the bottom of the page, in terms of evidence from Fujitsu, we believe we will need 3 categories of evidence are set out. Having spoken to Fujitsu, there are parts of points 2 and 3 that only Gareth Jenkins can realistically provide. To be clear, Gareth will be called as a witness of fact. He'll be providing descriptive evidence of systems and procedures, and perhaps his investigations of certain bugs. He's not being asked to give an opinion. The opinion will be, over the page, be given by our expert evidence, Dr. Robert Warden, based on the factual foundation set out by the witness evidence of Fujitsu. The COM will be with Tony Robinson and Simon Henderson. The purpose of the conference is to discuss the risks of using Gareth Jenkins as a witness, given his previous role as a prosecution witness. Thank you. But before this conference, I think you probably knew that Mr. Jenkins had been regarded by the Post Office as a witness who had breached his expert duties and was being blamed by the Post Office for the need to review some convictions. Were you, before the conference, proceeding on the basis that Mr. Jenkins would be a witness in the civil proceedings?
I'm sorry, there was a big run-up. I think, sorry, I lost you when you said we were looking to blame Gareth Jenkins. I'm not sure that's correct. Could I have I lost you on the question, sorry, my head went to that.
Before the conference, were you proceeding on the basis, as Mr. Parsons set out, that Gareth Jenkins would be called as a witness?
No, I think we were proceeding on the basis that he wouldn't.
This suggests the opposite, doesn't it, before the conference? This says he is going to be called as a witness.
Well, I think the purpose of it was whether he is or isn't. The purpose of this conference was to determine whether he would or wouldn't.
You tell us in your witness statement that a firm view was taken at the conference that the Post Office should not rely on Mr. Jenkins because, quote, of his previous involvement as a witness in the Post Office prosecutions. Yes?
Yes.
Was that the decision that was effectively taken?
I believe so, yes.
Was any decision taken at that conference as to what use Mr. Jenkins would be put to behind the scenes?
I don't recall, but...
This can come down from the screen, thank you.
Quite possibly, yes, because it was all I recall, I don't recall the specifics, but I remember it being, there were a few lawyers in the room, as you pointed out, a fairly sort of full discussion of what the issue was and how it might play out. I confess I don't remember the detail, but it's possible that was, yes.
Was there any discussion or a decision made that Mr. Jenkins should be a form of sort of shadow expert witness and contribute indirectly to the Post Office's case by, for example, feeding information to witnesses that it did choose to call at the trial?
I don't recall that they used this, again, there's a bit in there, the phrase, I don't recall shadow expert being used at all. I don't recall that you were quite specific about what went. I don't quite recall, but what was discussed. But thinking about it now, it's an obvious question. If we're not getting evidence from him, how does Post Office present the evidence it needs? If it needs evidence, and it would have come from Mr. Jenkins, how else does it get it? And so if Gareth was, as he is, sort of, the architect, I think the original architect of the system, it's possible he would need to provide information that the Fujitsu witnesses could provide. but I don't recall whether that was discussed in the conference or not.
Taking a step back from the narrow confines of the conference, what was your understanding of the use to which Mr. Jenkins would be put in the course of the group litigation?
He would be available to provide technical evidence to Fujitsu witnesses to enable them to give their evidence in the group litigation.
The Post Office had dropped him as a witness, hadn't they?
Yes, I think that's fair, yes.
Back in 2014?
Oh, yes, definitely.
2013?
For prosecutions, yes.
And they'd done so because they'd been advised that he'd breached his duties to the court.
Yes.
And he was a tainted witness.
Yes.
What measures, guardrails were put in place for his use behind the scenes in the group litigation?
I wasn't close enough to that work to know, I'm sorry.
To your knowledge, were any such measures put in place? Guardrails, as I've called them.
Not to my knowledge, but I don't know whether they were or weren't.
Yes, Ms. Williams, thank you very much indeed.
Thank you.
The order, I think, has been agreed between the court participants that Mr. Henry first, then Mr. Jacobs, and then Mr. Maloney. I've just been told that we need a 5-minute break before the questions start.
Yeah, well, that's fine, because by my timepiece, it's getting close to 12, so that if we have a 5-minute break, then Mr. Henry will have the opportunity to ask questions till 10 to 1 or thereabouts, and then we'll break for lunch, yeah?
Thank you very much, sir. So, good afternoon. Can you see and hear us now?
Yes, I can, thank you.
I think there are some people who are still finding their seats. Yes, I think it's Mr. Henry to start.
Yeah.
May I begin, sir?
Of course, yes.
Thank you so much. You're a lawyer,
Yes.
not a fixer.
I don't know what you mean by fixer.
Well, you're not a spin doctor, are you? You owe duties to the court.
Yes.
You also have duties established under your code of conduct, don't you?
Yes.
In representing your employer, the Post Office, during the period 2012 to 2021, did you discharge those duties at all times?
I certainly sought to.
Did you discharge them faithfully?
I would hope so. I believe I did.
I strongly suggest you did not, and that you know you did not. What do you say to that?
I'd like to know why you think that.
I strongly suggest you did not because you were part of the suppression, obstruction, and cover-up of people's Article 6 appellate rights, weren't you?
There's a lot in that. I'm sorry, I don't even have the article in front of me.
You knew that the CCRC eventually, after years of delay, were dependent on the outcome of the Horizon Issues judgment, didn't you?
I don't know what the CCRC's investigation or timeline was. I'm sorry. That's the CCRC's work.
Well, we'll come to that in a moment, because I suggest that you knew very well how the CCRC were progressing matters and how people on your behalf have been dripping poison in their ears about there being an explanation for everything to do with the complaints that the sub-postmasters had made. But let's start off with something surely which is uncontroversial. By 2015, any reasonable prosecutor or respondent would have had questions about Horizon's integrity at the forefront of their collective minds, wouldn't they?
Yes.
So I want you to go, please, to your bundle, B for Bravo, 202, and for us, it's POL 001 01968.
202, was that?
B202.
Thank you, sir.
Could you turn to page 3 of B202?
Yes.
Do you see an email there from Jarnail Singh dated the 8th of January 2015?
Sorry, Mr. Henry, it's not on the screen yet, and I'm following it on the screen. Now it is, thank you. Yeah.
I'd be very grateful if one could go to page 3 of that document. And could we go down to the bottom, please? Yes, Jarnail Singh. Do you see in the second paragraph, whilst the Post Office wished to say that there are no systemic faults, the Second Sight interim report, which has been disclosed to the defendants and their legal representatives, does mention 2 defects, bugs, which give rise to 76 branches being affected by incorrect balances and transactions. It's described as systemic but not system-wide. And then let's omit words, and could you go a few lines down, and you'll see it's in the middle of the body of that paragraph. The difficulty here is made worse by the fact that Garth, not Gareth, but Garth Jenkins, an employee of Fujitsu, has been making statements for use in criminal proceedings which made no references to the very bugs which it is understood he told Second Sight about. People were prosecuted and pleaded guilty following the receipt of his statement, which implied no bugs had been found. Of course, it would be highly embarrassing for Pol were it to be suggested that Fujitsu had informed some part of Pol and that information never reached the security team. Do you see all of that?
Yes.
And this, of course, was in connection with the BBC Inside Out request for an interview, wasn't it? We can see that on the subject line.
That is in the subject line, yes.
Yeah. Now, you were aware, and I'm going to suggest to you in the strongest terms, by this time, you were aware of the problems, of course, with Gareth Jenkins, weren't you?
Yes.
You were also aware of the bugs that Second Sight had concentrated upon.
Yes.
And I suggest you were also aware, or people in your legal department were aware of remote access. So there was a constellation of difficulties facing the Post Office, wasn't there?
There were, I don't know what a constellation of difficulties is, I'm sorry.
You know perfectly well it's to do with Second Sight, it's to do with Gareth Jenkins and the Clark advice, and it's to do with the fact that there were people in your department who knew about remote access.
The first 2 bits, I'd say yes. The remote access in 2015, I'm afraid I can't quite remember where we are in the timeline on remote access there. So I can't say yes or no to that, I'm sorry.
We'll come to remote access later on. This is how you dealt with it. So you have Jarnail Singh at 1551. Could we go to page 1 of the document now, please? And could we go down to your response on the 8th of January 2015? And you see, this is what you say. All. How about this? Only a court can overturn a criminal conviction, etc., etc., etc. Go to the next paragraph. Post Office is acutely aware of the duties imposed on it when it brings a prosecution and is confident that it has acted in accordance with those duties at all times? You knew perfectly well that that wasn't true.
No, I don't, because I go on to say, I put it to the criminal lawyers, John L. Singh and Martin Smith, saying, well, to John L. I say, copying Martin, and saying, does that work? And then I go on to say, we don't want to refer to the review because it will just open up another line of inquiry, question mark. So I don't think I knew, which is why I put it to the criminal lawyers who I felt should or could know.
And did they suggest that that was unwise?
I don't recall what the response was.
Because we've already heard about misleading briefings to the BBC, haven't we, when Mr. Beer was asking you questions. You knew perfectly well when you wrote that that wasn't true, didn't you?
No, I don't agree. I wrote that because I think that's what I understood the position to be. I think it is fair that we were acutely aware of the duties imposed because we'd taken quite a bit of advice on that. Action had been taken as a consequence of that, and that's why that formed the foundation for the confidence that it had acted in accordance with those duties. But I was quite keen not to make that statement, or that statement not be made, until those better placed to understand it would be able to respond, which is why we put the criminal lawyers on there.
You knew perfectly well that Pol had failed in its duties of disclosure.
Yes.
You knew perfectly well that it had relied on a liar and a perjurer to convict innocent people.
I don't know that those necessarily follow. I knew that part of this was the evidence that had been provided was not reliable. But in the criminal law context, I just don't know to what extent or how.
Come off it. You'd read the papers. You'd had Seema Misra's papers on your desk from 2012. You knew perfectly well that he had given evidence in Seema Misra's trial and that he was instrumental. He was, in fact, the only reason why she'd been convicted.
I'm sorry, I don't know those things.
Let's go to your E95. POL 001 555 39. And could we go through the document, please? That's your notebook from the Bates and others post office trial, isn't it?
I'm sorry, could I have a bundle reference, please?
It's E95.
Thank you.
Could we go to the text, please? Thank you. Have you got it now?
Yes, and sorry, the page number on it?
It's the first page, Horizon Issues Trial, 5th of June 2019.
Sorry, first page, got you. Sorry, thank you.
And do you see in parenthesis, question mark, peak on Misra, F/333, arrow, go to CCRC, question mark, and then beneath that, check with Mandy. Do you see that?
Yeah, I do.
Mandy Talbot, correct?
I don't know. There may have been a Mandy in the WBD team who was working on the...
Do you know Mandy Talbot?
No, I don't.
You don't? Well, who was Mandy? Check with Mandy.
I'm sorry, I don't recall at the moment.
Right. Let's just take stock here. This is now 2019. From 2013 onwards, you had the Russian doll, didn't you, of the Cartwright-King review, the Altman review, on top of the Cartwright-King review, and then the Bond-Dickinson review of Altman's work. Correct?
I don't believe Bond-Dickinson reviewed Brian Altman's work.
You've just said that earlier today in questions put to you by counsel to the inquiry, that his review was being reviewed by Bond-Dickinson.
If that's how it came across, and I'm sorry, I don't recall Bond-Dickinson review. I think they assisted in ensuring Brian could review Cartwright-King's review, but I don't recall instructing Bond-Dickinson. They weren't criminal lawyers, so it wouldn't have made sense.
Or did you make a mistake? I mean,
I'm sorry if I did. That's what I'm trying to say. I don't believe that would be my evidence. I don't recall Bond-Dickinson reviewing Cartwright-King. Sorry, I don't recall Bond-Dickinson reviewing Brian's review of Cartwright-King's review.
well, there will be a transcript.
What Mr. Henry has in mind is that Mr. Parsons, I think it was Mr. Parsons, wrote an email making suggestions after Mr. Altman had produced his review. And I take it, Mr. Henry, that's what you're referring to, is it?
Sir, that's correct.
Yeah.
Sorry, I could probably so that was. Sorry, because I'd like to make sure my first stuff is understood. So, my understanding of the way the questioning came, and again, I'm sorry if this hasn't come through, is that and I think it was Gavin Matthews, sir, who may have written that email from Bond-Dickinson, but it may equally have been Andy. That came, I think, in response to Brian's initial assessment or his first look.
Did you work closely with him?
With whom?
Brian.
I described as we've worked together, or he's been instructed by post office on matters where I've attended, on and off.
First name terms?
When I meet him, yes, I would say. Hello,
When did you
Brian.
last meet him?
I think it was at the conclusion of the Hamilton and others Court of Appeal Criminal Division hearings.
When did you last speak to him?
From memory, I think probably back then. I don't believe I've spoken to him since, but I may have done.
Let me return to the words in parenthesis. Question mark, Pecan Misra, F333, go to CCRC, question mark. The post office was fighting the GLO tooth and claw because you all knew that if you lost the civil litigation, a cascade of criminal appeals would follow, didn't you?
I don't recall turning my mind to that at the time, no.
I suggest you're lying. There was a strategy in the GLO which was coordinated with the pending appeals, wasn't there? Fight it at all costs.
There was certainly discussion around appeals to the common issues judgment at that time, yes.
Even recuse the judge to put a spanner in the works.
Post office made an application to recuse the managing judge, yes.
Why did you need to check with whoever Mandy was to disclose to the CCRC something blindingly obvious, the peak in Seema Misra's case, which was not disclosed to her before she was convicted?
I don't know. This is my notebook of the trial. So you can see in the right-hand column, I sort of draw a line and I try and put references to the transcript so I could come back. So these are issues arising from the trial that may or may not have required check. It's my shorthand of live evidence. So it's.
Why did you need a question mark? It was blindingly obvious.
It may have. It clearly wasn't because I put a question mark.
I suggest that this again was part of the cynical, can we delay, can we get away with it mentality. What do you say to that?
I'm thinking, and no, I don't know how a square brackets in my notebook feeds into a delay tactic.
Well, let's go to, you say you didn't at any stage adopt a cynical approach to disclosure.
I don't believe I said that, no.
So let us go to your document B182, which is POL 001 03238.
So, B, which number, sorry?
Bravo 182.
Thank you.
And could we go, please, to page 2? And this is you writing to Andrew Parsons, Andrew Pheasant, and Gavin Matthews. And they're all of Bond Dickinson, aren't they?
Yes, they are.
Right. Let's omit the first paragraph.
I do apologise.
B182.
182, I'm sorry. I am sorry. Yes, I have it, thank you.
Do you see the first paragraph? I'd like to start thinking about whether and how we can start forcing the issue with the CCRC. See that?
Yes.
And also, you use the expression, I'm also conscious about the noise about the receipt and payment mismatch issue and its effect on MISRA, to which the document requests may be linked. And that, of course, was, as we can see from the rest of the document, no need to take you to it, was the CCRC's attempts to get information from the post office. Do you agree with that?
Yes.
Do you agree that noise is dismissive?
It didn't mean to be. It's a shorthand email that I think was sent from a BlackBerry that tried to summarise what was communication, discussion, generally.
It's dismissive, isn't it, in tone? It's just noise.
I didn't say it's just noise. I don't know what more I can say. That's the word I chose to use.
You were hoping, by any means, to bring the CCRC proceedings to an abrupt halt, weren't you?
No.
Let's go to page 1. And there are 4 bullet points, aren't there?
Yes.
Now, you recall that this is 2016, and the very issue that you've described as noise, the receipts and payments mismatch issue, the Court of Appeal in Hamilton saw that that was a key ground of appeal. You don't disagree with that, do you?
I agree with it, yes.
Yes. The Post Office didn't have a leg to stand on, and you knew that from May 2016 with Tim McCormack's Freedom of Information request, didn't you?
I think there are 2 bits. He gave me a date and an item. So on the first piece, I didn't know. I've never known about the safety of convictions. I'm not a criminal law lawyer. The second piece, you've referred to an email which might...
You know perfectly well what I'm referring to because you were taken to it by counsel to the inquiry. I'm talking about Mr. McCormack's Freedom of Information request, where he spoon-fed all you needed to know about the injustice that Seema Misra had suffered.
I'd be grateful if I could be taken to the document.
I'll take you to it in due course.
Okay, thank you.
But you were already aware of that because he'd sent it on May the 20th, 2016. Let's go to page 1 of your B182.
182. Yes.
I put to you that you were trying to frustrate and bring the CCRC proceedings to a close by any means possible. Do you disagree?
I do disagree.
Well, let's have a look at the advice you received. Number 1 bullet point, push them on their jurisdiction to take this action, which was slightly tenuous at the start. So challenge and push the CCRC on their jurisdiction, correct?
That's been put forward as a possible area to develop, yes.
Apply some political pressure. Business, Innovation and Skills, MOJ, the Ministry of Justice, the Department for Business, Innovation and Skills as was, you were going to try, or at least that was the advice you received, to get them to bully the CCRC, correct?
No, that's that's reading a lot into it.
Political pressure.
These are bullet points for discussion.
Oh, I see. Just to discuss. Tell the CCRC, this is number 3, that you're coming under increasing pressure internally to know when the CCRC is likely to have completed its findings. Can Amanda help? That was Amanda Pierce of the CCRC, wasn't it?
I would think so, yes.
Because you'd schmoozed her, hadn't you?
Yes. I don't know.
You developed a very good rapport. That's why it was being suggested that you were trying to get Amanda to help you.
She was our contact point, so if we were to raise that issue with her, she would be the contact point.
And then finally, this effectively tell the CCRC that they must decide this before the civil matter, close it down before the civil matter, or get the criminal claimant stayed. That's a fair summary of bullet point 4, isn't it?
It's not, but bullet point 4 is, I think, sufficiently summarised.
You don't disagree, though, that that's what it is. Real danger that any delay in the CCRC investigation will cause those claimants' cases to be stayed, pending the result, i.e. the CCRC investigation may hold up some of the civil case. That's what you were trying to do. You were trying to bring...
Again, I think I don't agree with your interpretation of these documents because they're trying to import onto me things that where I was just weren't the case. If we go back to what I'd said is we'd had another request for information from, and I think this is what I said yesterday on the same line of questioning. We'd received another request for specific detailed, as Mr. Beard put to me, questions. I thought it was time to, and I said quite thickly, could we I'd like to start thinking about whether and how we can force the issue. So the key piece is whether, and it follows from that how. Part of that is we'd been engaging with the CCRC for quite some time, and it struck me off the back of this, and I checked my dates when I was preparing my statement. I think I was on my way back from holiday to receive this. This is an opportune time, particularly in the summer break, because it's August, to think, are we approaching, is the approach we've been taking to date, cooperation, support, but leaving them to get on with it, is it the right one? Let's kick the tires and see if it's still right. And to the best of my recollection, we did not change that approach.
You knew they were in disarray, didn't you?
Who is they, sorry?
The CCRC.
I did not know that. No.
Well, let's go to page 2 of B182. Amanda Pierce to you. Bullet point 2. We're trying to locate the transaction logs for the Misra case, etc., etc. Omit words. Let's go over to bullet point 2 on page 3. We've seen a number of references to the receipts and payments mismatch problem, which we think has also been referred to as the Calendar Square Falkirk problem. Well, they weren't right about that, were they? I mean, they were in complete disarray, weren't they? Look at bullet point 3.
I can't speak for the CCRC, and that was never my impression of them, no.
You knew from your position of knowledge that they were nowhere near being ready to determine this case, these cases. You knew from your knowledge, it's obvious from reading that they were not apprised of important information or had misunderstood important information. Now, I want to come now to the Seema Misra case. Mm-hmm. I'm going to ask you to confirm that you were aware of that case and Gareth Jenkins' part in it from a very early stage, weren't you?
Yes.
Yeah. And in fact, on the 1st of July 2013, you were aware that Gareth Jenkins was a witness in Seema Misra's trial because Jarnail Singh had sent an email to you and to Hugh Flemington.
Are you going to ask me a question on that email?
Well, if you want to see it, I'll put it to you. It's POL 000 31352. You won't have it in your bundle, but you will be able to see it in much larger font on the screen.
I think this is in my bundle. It looks... Oh, yes. Yes, I have seen it.
Yeah. Yeah. So the 1st of July 2013, paragraph 3, we instructed our own expert, Gareth Jenkins from Fujitsu. This was a turning point in the case, etc., etc. Paragraph 4, Professor McLachlan conceded that all of the theoretical problems he'd raised were now irrelevant. He abandoned most of his theories after being assisted to a better understanding by Mr. Jenkins, etc., etc. So again, you knew, certainly no later than the 1st of July, that Gareth Jenkins was absolutely instrumental. Now, it's fair to say, isn't it, that even without this email, the Misra and Castleton cases were of interest to Second Sight, and anything of interest to Second Sight was of interest to you, correct?
I can't speak for Second Sight, and I don't know if you as me personally or you post office, because there might be a different answer.
Yeah.
Could you
remember
ask me the question again? Sorry.
Yeah, well, don't worry. Do you remember yesterday saying that it was important to keep things under review?
Yes, and I think I've said it.
Yeah, because your role involved detail, didn't it? Distilling and appreciating the significance of information you received.
Certainly distilling, detail, sometimes yes, sometimes no.
You can't distill something without appreciating it, can you? Because, of course, distilling something means you have to comprehend it and reduce it to précis.
Hopefully, yes.
Yes, exactly. Hopefully. Now, you'd read the advice of Simon Clarke dated the 15th of July regarding Gareth Jenkins the very same day it was written, didn't you?
It was certainly around the same time. It would have been fairly close to it. I don't remember precisely when, but...
It was apocalyptic, wasn't it? I mean, you knew that he was a fatally discredited witness who was a key witness for the Post Office in numerous cases, and that this would have a profound impact on historic prosecutions. You knew all of that.
Well, I knew the advice, yes.
Right. So you knew by the 15th of July that he was a liar, that he'd failed in his duty to the court, and that he was bankrupt credibility. Is that why you, on the 22nd of July, were concerned about a holding letter to the CCRC, so a week later, a holding letter to the CCRC, and also notifying the Post Office's insurers?
Sorry, 22 of July of which year?
A week after you'd read that advice...
A week, sorry, so 13, yes.
A week after you'd read that advice, you were concerned about drafting a holding letter to the CCRC, and also you were concerned in relation to the question of notification to the Post Office's insurers. You must remember that.
So I remember the second bit. I'm sorry, you're taking me to documents and time series, and I've looked at a lot over a long period in the last few days, and I'm struggling to follow. And I am sorry for that, but I am trying to follow you. Can you break it down? Can you break it down a bit?
I don't need to take you to the document. It's a matter of record. I'm just going to come back to the Clark advice.
Okay, thank you.
The Clark advice, did it not strike you that Seema Misra's solicitor should be informed immediately?
No, I think that was the very first engagement I'd had with the criminal law process, let alone specific cases. But there are the criminal lawyers looking at these matters and advising the company. So that wouldn't have been my role.
But look, let's please not dissemble. We know from your handwritten documents of your discussion with Martin Smith, dated the 2nd of September 2013, your E96, that you must have had carriage of this, because otherwise you would not be discussing the matter with Martin Smith.
The heading of the note was that the only piece of carriage I had was how Post Office would engage with Fujitsu over that. That was my carriage of this. I'm not a criminal lawyer. I couldn't comment on what to do with it. It would have.
That note, I suggest, which is your E96, POL 001, and then 5 fives, obviously and completely undermines your suggestion that this was nothing to do with you, and it was all to do with the criminal lawyers.
In terms of giving criminal advice to the company on what to do in response to the second site's report, I do not believe I gave any advice to the company.
You had liaison with Brian Altman, didn't you?
I attended conferences with him, and then later on I would say liaison, yes.
Can we scroll up, please? Can we scroll up? I want to... Sorry, if we could scroll up so that we can see further down in the notes. And further down, please. And further down. And further down. And further down. And you see that LS to come to BAQC.
Yes.
Is that legal services?
No, I think that's Leslie Sewell, who is the Chief Information Officer.
I see. Right. So you were involved in relation to that?
I don't know what the that is. I don't believe Leslie came to a conference.
Arranging the consultation with Mr. Altman with the Chief Information Officer.
Yeah, I have a funny feeling that's probably missing a question mark, because Leslie didn't come to any conferences or consultations with Brian, as far as I remember.
So I suggest to you that you didn't just read the Clark advice and put it away, that you were involved in dealing with the fallout.
Yes, I helped Post Office manage it as part of a number of people. I'd hope I've been clear about that.
And part of that fallout, of course, was drafting a letter before claim, wasn't it?
I can't remember whether I drafted. That was something that was drafted, yes.
Yeah. And was that letter before claim sent?
I don't believe so, no.
You don't believe so?
In fact, I do not believe it was sent.
You don't believe it was
sent? If that's clear.
Right. Can we go to that letter before action, POL 001 40620 at E77, your E77.
Thank you, sir.
And can we go a little bit further up, please? And over the little bit further up. A little bit further up. Right. Do you see just above Fujitsu's obligations? You drafted this letter.
From the font, it looks like a Wimble Bond Dickinson produced document, a Bond Dickinson piece.
So Bond Dickinson did?
I don't know, but it looks like their format. And I think they did. I think they did, yeah.
Was there a little bit, I mean, I know that it wasn't sent, but was there a little bit of a puff? In a number of cases, Post Office has now been forced to stop prosecutions, correct, and notify these disclosure failures to Defence Counsel in cases where sub-postmasters have already been convicted. You would have known that that wasn't the truth, wouldn't you?
I'm sorry, which part?
And notify these disclosure failures to Defence Counsel in cases where sub-postmasters have already been convicted.
I'm looking at that, and I think that reflects what I've understood to be going on with Cartwright King's review of past prosecutions.
It's suggesting that people have already been contacted. That was not accurate.
If it was saying at this time people had already been contacted, then that probably would not have been correct. But this is a draft, and it's referring to Post Office's actions. So,
thank you.
Okay.
Can we go to your E89, please? E89.
Yes.
This is POL 001 52451.
Yes.
And you can see in the second paragraph the MISRA angle, and this is the 26th of June 2015, could be whether proper disclosure of Horizon bugs was made to Professor McLachlan. Wasn't just that, was it? It was to do with the fact that a perjuring witness had given critical evidence in her trial, and you knew she hadn't had a fair trial.
Again, I don't know about the fairness of her trial. That's not a matter. I think this document probably relates to the Panorama program when we were trying to understand what might be contained in the broadcast and hence what Post Office might wish to be alive to as an issue and what it might want to do as a response to it. So it's...
Can I go now, please, to your E111, and it is POL 0024 3328.
I have it, thank you.
Just to let you know, Mr. Henry, we're getting close to the 45 minutes, all right?
Thank you, sir. This is another email where at paragraph 11 of the bullet points from Jarnail Singh, which you were aware of from the 11th of June 2014, again about Gareth Jenkins being the turning point.
Yes.
And at paragraph 20 of this note, paragraph 20, please, page 4. And it says, last sentence, I can say is that both sides in MISRA were completely beholden to Gareth Jenkins and his deep knowledge of Horizon. Can you explain, in those circumstances, you knowing of that from 2014 and you actually digging it out on the 20th of July 2016, because we can see that from page 1 of the document, why Mrs. Misra's team, Mrs. Misra's lawyers, weren't informed of that as soon as you read that?
Well, the email goes back to 2014, I think, at which point the review as appropriate of past convictions for safety was being undertaken by the lawyers. It looks like I brought this up in connection with the mediation scheme and a case of M012, which I suspect it was the number given to Mrs. Misra's application to the scheme, and I was forwarding it to members of the scheme team as a summary of some of the criminal law assessment of, in fact, it's back to M12, so it even rose. This was all generated in connection with.
What about your personal responsibility? Rather than saying this is nothing to do with me, it's to do with the criminal law team, what about your personal responsibility? You refer to this on page 1 of the document as a wee beauty that you can use to advance the post offices.
In terms of my personal responsibility, at some point, and I can't. I think there are emails in my bundle somewhere on this. At some point, in fact, it was the subject of one of the Rule 9 requests. I expressed that I was uncomfortable about. It became clear to me at some point in this, and I think it was probably around the time of the panorama, that the receipts and payments mismatch bug was in play during the course of Mrs. Misra's trial. I didn't know in the context of criminal proceedings what that meant, but I sought some advice on it. So that you have to have personal responsibility. I sort of said I felt uncomfortable, but again, in the context of criminal proceedings, I don't know what to do.
So you delegated it to Cartwright King and to Mr. Altman?
I think initially, I wouldn't say delegate. I think I'd ask them. I'd ask them, here's an issue, what do we do? I think that's a request for advice.
Mrs. Misra's conviction was eventually quashed in April 2021, 10.5 years after she had been wrongly convicted. You were personally aware of information sufficient to quash her conviction from July 13, weren't you?
I had information. Whether it was sufficient to quash or not, I keep saying I don't know.
You had all the information that was deployed in her appeal on her behalf from 2016 because of the Second Sight Review and Tim McCormack's Freedom of Information request.
I don't know whether I had all the information or not, and you're referring to documents that I can't
So
see.
I want to come finally, and this is my last question, sir, to E111. And this is POL 00243 328.
So B 111.
Yes. It's your E111.
I have the document, thank you.
Yes. And again, could we go to page 8 of your E111?
Yes.
And this is you in 2014, 11th of June 2014, and you're still, as it were, asking your comms team to do a little bit more to help them tell our side of the story. You want more information from Jarnail Singh to help the comms team tell your side of the story. What was your side of the story, Mr. Williams?
Would be Post Office's position on the prosecution of Seema Misra was at that time.
It was all to do with spin and nothing to do with the fact that this woman had been wrongly sent to prison. Isn't that the truth of it?
Well, this email is sent to the comms team, so it is for a communications exercise. That's what that email seems to be connected with. I'm trying to join the criminal lawyers up with the communications team so that a communication can be crafted for whatever purpose.
What about the substance? A wrongly convicted woman. What about that, Mr. Williams?
What specifically about that? I can say I take no pride, comfort, or confidence in having worked for an employer that's engaged in conducting the greatest miscarriage of justice that we've seen, however it's been described. It's never been. I don't know where to go with this. It's awful that people with convictions had them for the length of time, and then had them for the length of time they did. And from my part in that, I'm truly sorry. That I've been associated with this. I think I'm truly sorry for that.
You weren't associated with it, Mr. Williams. You were in the middle of the web and you were part of it. Thank you, sir.
Thank you, Mr. Henry. I think the point, Mr. Williams, is that at a moment in time, namely 2014, when on any sensible reading of Mr. Clark's advice of July 2013, there was a problem about Mr. Jenkins's evidence. The Post Office and you personally appeared still to be asserting to the world that the conviction was safe, amongst other things, because expert evidence had been called and the jury, by inference, must have accepted it. And those two things don't sit very easily together, do they?
No, they don't, sir. No, they don't.
Thank you. Then we'll adjourn now until 2 o'clock, and we'll have questions from Mr. Jacobs.
Thank you, sir.